IVM.
On January 12th, 4 judges of the Supreme Court did something extraordinary. They called a press conference. Exciting. Let's do a podcast on that. Welcome to the Pragati podcast. I'm your host, Pavan Srinath, and welcome to this weekly talk show on economics, public policy, and international relations. Last Friday, 4 of the senior-most justices of the Supreme Court, Chalameshwar, Gogoi, Joseph, and Lokur, came together and criticized the Chief Justice of India, Deepak Mishra, and his predecessors. The judges complained that the Chief Justices had not used their administrative powers correctly. Note how guarded the language is. The judges did not allege, they complained. Joining us in studio to help us understand what's happening are Harish Narsappa and Alok Prasanna Kumar. Harish is a founding partner of the law firm Samvad Partners and is a co-founder of Daksh India, who work on strengthening the rule of law and evaluate judicial performance and promote accountability. Alok is a senior resident fellow at the Vidhi Center for Legal Policy and heads their Bangalore office. Vidhi conducts independent legal research and also assists governments in drafting better laws. Alok was also a former Supreme Court advocate. This week, the episode is extra special thanks to the cold that I have, which is blocking my sinuses. Alok, let's take a step back. First, the idea of a press conference sounds very boring, right? Anyone can call a press conference, but the idea that 4 of the senior-most judges doing this was in itself quite significant, right? No matter what the topic of it was.
Yes, and judges don't speak to the media. Almost as a matter of course, they are very media shy, both by training and by institutional norms. And usually, whatever disagreement there is, and I don't think there is any institution of that size which doesn't have internal disagreement, it's either sorted out inside or people let things go in the interest of the institution. I think what we are seeing is, and I think what this particular press conference also indicates, is that things had reached to such a head that the first 4 of the senior-most judges of the Supreme Court of India felt that we just can't let this lie. As they prefaced their remarks, we went and spoke to the Chief Justice. He did nothing. He didn't want to do anything. And we felt letting this lie will affect the institution. I think what they have done is to sort of say that, look, this is an issue where the institution's credibility itself is at stake. Individually, whatever limits may be imposed on us, we're willing to take the risk of trespassing that a bit in order to protect the institution itself. So in that sense, yes, it is very significant. It sort of shows you the kind of challenges that are there in the institution, that the institution itself is facing internally. Now, to take a step back, as the Supreme Court was envisaged in 1950, it's a very different body that it is today. You have a sanctioned strength of 31 judges. So any point of time, you have between 25 to 30 judges in the Supreme Court. You can't run that court on the basis of norms and conventions that evolved in a much smaller court. Now, this is something from personal experience, but what I found when I was helping set up Vidhi, and as I saw it grow, is that the dynamic of in any organization with about 5 to 10 people is very, very different from
now,
the dynamic.
5 to 10 people, you're operating on trust.
And
you don't need rules. The norms work.
Yeah. But when you get up to that stage of about 25, and we're not talking about anybody being subordinate to the other, you're talking about 25 equals. Right? And you need rules, you need procedures, you need to sort of stick to the letter of the law more often than not. And that is what the Supreme Court has really failed to put in. I would not just say in the last 1 year, but in the last 2 decades. And we have seen that come to a head in the last 1 year. We have seen that failure most publicly, most egregiously, I would say, in the last 1 year, when the failure to put in the necessary rules, the systems to help an institution go along, come out into the public. And that sort of shows that the institution itself is being weakened from within.
See, if I may add to what Alok is saying, at some level, this is all about power, right? And look at it. I mean, this is not about writing judgments. The disagreement that has come out in the public is not about writing judgments.
Right.
At that level, they're all equal, right? Everybody has, when you're sitting on benches, I mean, everybody is an equal. It's one person per vote. Nobody has a casting vote.
But and you can write a dissent note and that system works.
You can write whatever you want. I mean, at that time, you're only guided by your reasoning, legal reasoning, and precedents and statutes and constitution and all of that. But this particular administrative power is like any other exercise of power in any other institution, and that is unregulated, right? And the exercise of power on the administrative side has become so vital to the functioning on the judicial side as well, and that is the key, right? Who do you allot matters to? And none of us pay attention to what happens in the high courts, right? We are all focused on the Supreme Court because the media is focused on the Supreme Court, and the most important matters come into the Supreme Court. But the high courts, this is more rampant. What kind of matters are given to different judges, and what kind of sensitive matters there are. Take a step back. I mean, the kind of allegations that I won't say allegations, the kind of complaints that the 4 judges made are being done every day in each high court, right? By other judges, by the lawyers, okay? And there are always allegations about some considerations that are not, that are extraneous in nature and not relevant, play when decisions are being made on bench selection in the high courts as well. So, and mind you, the high court judge also exercises supervisory control. The chief justice is the boss of the judiciary in the state, and the power that he exercises is enormous, more than the power exercised by the Chief Justice of India. And if there is nothing to regulate that power except the moral authority that some senior judges may possess, and not all senior judges in high courts have the same moral authority as these 4 gentlemen, who went to the press conference did. So we are looking at an institution that is functioning without any rules. And Alok is absolutely right. You can't have norms governing decisions that affect delivery of justice as well, but don't directly intervene in the judgment-making process. But it affects the justice delivery system.
Harish, what happened on January 12th? The judges calling a press conference. Is this the wake-up call that the rest of us have been waiting for? Will this spur action? What's really happening?
I think this is the most visible wake-up call. I think there were 2 parts to your question. One, whether this will spur new activities in judicial reforms, and 2, whether this will lead to any institutional reform. Judicial reforms, I mean the wider judicial reforms across the country.
From the police to the
Supreme
laws.
Courts, high courts, police, laws, subordinate courts. Institutional reforms, just in the way the Supreme Court functions. Now, I think the reality of some institutional reform at the Supreme Court level is also very difficult. What this may lead to is a change in dynamic between the Chief Justice of India and the senior most judges of the Supreme Court, who form part of the Collegium, or even a wider set of senior judges, maybe 5 or 6 senior judges, and how they talk to each other and what is the power equation amongst them. That is one. And similarly, in the various high courts, the relationship between the Chief Justice of the High Court and the senior judges. But I don't think this press conference and the issues that were raised in the press conference specifically, which were relating only to manner of allotment of work to different benches in the Supreme Court, I don't think the questions they raise necessarily will lead or spur different kind of judicial reforms or even institutional reforms at the Supreme Court level or the High Court level. What it does is it raises many questions on the way the Chief Justice functions, both at the Supreme Court and the High Court, the power he or she exercises, and the lack of accountability for the exercise of such power. So, my hope is that this kind of issues that the 4 senior judges have raised will lead to some sort of accountability measures on the exercise of power by the Chief Justice at the Supreme Court level and at the High Courts. Currently, there is no accountability whatsoever. The Chief Justice does as he pleases, and nobody can question him, and his exercise of power is not subject to judicial review. So he does whatever he wants.
So let's break down this power a little. What all powers does a Chief Justice have in the Supreme Court and in the High Courts?
See, actually, at the Supreme Court level, the Chief Justice didn't have much power until the Collegium got established, right? The Chief Justice's power was essentially to administer matters of the Supreme Court alone and nothing else. And then, by statute, the Legal Services Authority was added, so he got some power there. But apart from that, the significant power that he has today is the fact that he is the number one, numero uno, in terms of appointment of Supreme Court judges and High Court judges. And at the Supreme Court itself, on the administrative side, he has decision-making powers.
Primarily on the allotment of cases.
Primarily on the allotment of cases to different benches, and even constitution of benches, right? Who sits with whom?
Right.
Who sits on a 5-judge bench? Who sits on a 7-judge bench? Who sits on a 9-judge bench? And things like that. Otherwise, the Chief Justice of India does not have supervisory control of the High Courts. I mean, they're not bound to listen to him. I remember, the former Chief Justice of India, Venkatachalaya, was telling me once about how when he was in the High Court, somebody mentioned to him when he was sitting as a High Court judge that the Supreme Court had directed the High Court to do XYZ, and Venkatachalaya said, I told the lawyers that the Supreme Court can request us, they cannot direct us. So it is very clear that the High Courts are independent bodies, Supreme Court is independent body. The Chief Justice of India has become relevant because of the Collegium process, and by by a quirk of fate, even the importance given to these 4 judges who came out is because of the Collegium. Otherwise, see, these 4 judges are not superior in any way or inferior in any way to the other 21 judges in the Supreme Court, right? But because they are the 4 most senior judges after the Chief Justice, they form part of the Collegium. So there's more importance given to them. They're players in decision making.
Right.
So that's the sort of dynamic power equation that has developed. Otherwise, there's no power here, no real power in the Chief Justice of India, no real power vested in the Chief Justice of India, except because of the Collegium.
Yeah, that's right. And I completely agree with Harish on that. The power that we have really come to, and which is also the point that he made earlier, is that the Chief Justice decides who will hear what case.
Right.
Now, there are ostensibly rules that sort of say this category of cases goes to this person, that category of cases goes to that person. But the effectiveness of that rule is always tested in the exception. And in the exceptional circumstance, what we are finding is that the Chief Justice is exercising his power without rhyme and reason. Or at least nothing that is communicated to the rest of us, nothing is communicated to the public. And that is what is causing the problem. People will draw their inferences on the basis of a certain pattern. If they see in 3 cases, they went to this particular bench and had this outcome, they will draw the necessary conclusion that these cases were sent to this bench for this outcome. It may be possible that there are good reasons why that particular case was sent to that thing, but if you don't operate in a mechanism of transparency, you will end up with this situation. And I think Gautam Bhatia's piece today in the Indian Express has a very nice thing in the sense of how there is no match between the power of the Chief Justice and the accountability. You are a public functionary, then these are not just internal administrative matters. The Chief Justice has a lot of administrative controls, but this is possibly his most important administrative function. Who will hear what case? I do remember that when Chief Justice Kapadia took over as Chief Justice, he found that the listing system was in a complete mess. No rules were being followed. The registrars were running riot, doing whatever they want. And he took the effort in the 2 and a bit years that he was there to put in place some rules, some mechanisms, to ensure that cases are listed in a particular order. Cases are listed before a certain judge on a certain date in a certain way. But the next Chief Justice did not carry it forward. The next Chief Justice had his own ideas. The next Chief Justice has not. We've not institutionalized some of these things. It's an institution there, but some of these practices, conventions, and norms have not been institutionalized, and that's the problem.
So, can we learn from other places? Is this a solved problem? Or is the Indian case sufficiently unique?
It's sufficiently unique because I don't think there is any other constitutional court like the Indian Supreme Court, to the best of my knowledge. I don't think any other constitutional court has 20 plus judges sitting in multiple benches. I don't think any other constitutional court under its constitution, exercise such a wide jurisdiction as the Supreme Court. Everything from appeals and property matters all the way to constitutional interpretation goes to the Supreme Court. I'm not sure too many constitutional courts around the world have such a wide jurisdiction.
Right.
In that sense, and almost everybody will say this, the Supreme Court of India is sui generis. This is a problem which needs to be tackled on its own. There's a particular dynamic that the Supreme Court enjoys vis-a-vis the executive and the legislature, which we may not be able to learn from too many other countries. And that dynamic has happened historically. It's not just what was set in the constitution. There were certain events which sort of changed people's minds as to how the Supreme Court should function, what the Supreme Court should do. And we can't unbreak those eggs. We can't turn the clock back on PIL. We can't turn the clock back on the Collegium system of appointments. So for better or worse, we have to look at the Supreme Court as a sui generis institution and find mechanisms to address these kind of problems, keeping in mind the Supreme Court's position and authority in India.
I like what you said earlier, that rules and norms are often tested by the exceptions. Two such negative exceptions to court norms seem to be how the Judge Loya case was handled and how the medical college bribery case was handled, right? With those two cases and how they were handled by the CJI, the reasons for some of these judges to speak out?
I wouldn't say that, because this has been happening for a number of years now. Let's be fair and not just say this is something that started because of the current Chief Justice or the previous Chief Justice.
Okay.
It's been an ongoing problem. As Harish pointed out, it has been a problem which, like most things in India, has worked its way from down to up. Problem started in high courts. It wasn't fixed. People felt this is fine then, we'll continue doing this. It's worked its way down to the Supreme Court. And now, because there is no other place to go, it has now come up. It has come out into the public. So, to that extent, I don't think that it's just these two cases, right? I mean, they may be as I've been saying, the straw which broke the camel's back. But let's be fair and say this has been a failing in the institution for a while now. And now we have arrived at a situation where it can no longer be contained within and it has burst open into the public.
I agree. I don't think it's particularly these two cases which were the reason for it. It may have been the reason for determining the course of action these four judges took. But
Right.
even if you see the letter they released, they actually refer even to the cases relating to the memorandum of procedure and how it was before a constitution bench and it's been changed. And that happened prior to the medical council case and the medical college case and the Judge Loya case. But I mean, they're all different and unique, right? But the common thread is the exercise of power by the Chief Justice of India. I mean, if you ask me, I think the worst case was the medical college case, where even the basic norm of judicial functioning was disregarded. You can't sit in judgment on your own case.
Right.
That's a basic norm. And forget about who is exercising the power, whether the Chief Justice of India or whether it is the lowest Munsef. That norm was violated. And I think the medical college case gives us an indication of how random the exercise of power by the Chief Justice has become. Because in a matter of hours, or half an hour actually, a 7-judge bench was constituted, and then 15 minutes later it became a 5-judge bench, and actually the lawyer concerned was not even heard. And if you ask me, I think that was the day when, I've been seeing many newspapers calling this Black Letter Day or, Revolutionary Day for the Judiciary, Revolt Day, all of that. I think if you ask me, I know the day on which the 7 judges were constituted, then became 5 judges, and then they allowed lawyers not involved in the case to make presentations and passed an order without hearing the lawyer. I think that was the day, if you ask me, is a Black Letter Day. Not because of the personalities involved, but because of the violation of basic norms to which the judiciary adheres.
And so basic a norm. It's not even about some.
It's not even
working
about some great legal principle. It's about the essential functioning of the judiciary, a fair hearing.
Right.
And see, decisions are made by anyone, right? Even some tahsildars, in the district who are not even judicial officers by training, they make quasi-judicial decisions. The reason why the judiciary is so distinct is because as an institution, we follow reason, right? We give everybody an opportunity to be heard, then we reason out and follow the reasons in making decisions, and that is what gives everybody a satisfaction. Okay, I've been heard fairly. I've lost a case. That's okay. But if you violate that, then you're striking at the root of the judiciary, and that comes back to the point on power. I think both Alok and I were talking about. What happens when a person or persons come to exercise this power and they believe they're not accountable to anyone in their mind, right? The fact is there is no accountability of the exercise of power by the Chief Justice of India and the Chief Justice of the High Courts. Until now, many Chief Justices believe that they're accountable to their fellow judges and to the lawyers involved, and then the larger public. That's the hierarchy. Let's be very clear about it. I think they don't hold themselves accountable to anybody else. It's a brethren, right?
Right.
And but what happens when somebody comes and says, "I'm not even bound by those few factors that I operate by, right? That sort of attached to me because I've been a judge, right?" And that is what has happened here. And I was thinking about it, and I saw the newspaper headlines and everybody else. I was thinking, what else could these 4 judges have done? And where are they speaking from?
You preempted my next question. What else can someone do?
I'm sorry to have stolen your thunder.
Not a problem.
What else could you have done? And were these 4 judges pushed into a state of helplessness is another question that I have. And probably yes, looking from outside. And also from outside, not only from not being the judiciary, but also being away from Delhi, I think, which helps from time to time. What else could they have done? Because I saw many people making comments and well-known jurists making comments. They could have done many other things, but not this. But nobody says what that other thing was, right? And this is where the judiciary has sort of painted itself into a corner, right? And it goes back to Alok's point about sui generis system, that at least for the Supreme Court is concerned. They have painted themselves into a corner where they have told everybody else, don't intervene, we'll manage ourselves.
There were a lot of, the instant reaction of people is, why did they come out? In our country, that's the first reaction to anything that happens. When an institution is challenged, not when an individual is challenged. When an institution is challenged, the thing is, why did they come out like this? The answer in this particular case is, I don't think, and as Harish rightly pointed out, there was no other option. They aren't asking for a specific remedy from anyone. They aren't saying, as we usually file a case in a court, we ask for a prayer from the court and we ask an appropriate prayer from the court. They're not asking for that. They are saying, we just wanted to place the facts in public. The press conference, repeatedly people said, what happens next? What happens next? What happens next? And they said, no, we're not saying X should do that or Y should do this, but we feel the people in the country should know what's happening. The public should know what's happening. I'll give 2 recent examples as to how this can play out. We had Justice of the Karnataka High Court. What was his name? The judge of the Karnataka High Court who resigned?
Jayant Patel.
Justice Jayant Patel of the Karnataka High Court, who was overlooked ostensibly on the government's push by the Supreme Court for being appointed as a Chief Justice. And he resigned. And it caused enough of a ruckus that I think for the first time, bars in 2 different states came out in support of one High Court judge to say he has been unjustly treated. And that sort of prompted a reaction from the court to say, okay, fine. I see your point. We'll put out these rules in public. So, you opened the door a little bit for transparency. You had a massive reaction against the senior advocate designation system. Unhappiness across the country. Resulted in a case, bench coincidentally headed by Justice Gogoi, which said, you're right, this is a serious problem. We have seen all the material. Something has to be done. So here we are putting down norms in place. We are putting down an institutional structure in place. We are putting down certain things in black and white to say that nobody tomorrow can say, why did this person become a senior advocate and not that person a senior advocate? And we are going to create a mechanism where grievances can be addressed and so on and so forth. For the immediate short term, the best case scenario would be for the Supreme Court to say internally, yes, okay, this is a valid concern. Let's not focus on Judge Loya or the MCI bribery or the Calico pool case or any 10 others. You're right. There is a basic problem that we all agree on. Let's put in place certain norms. Let's say this is how the Chief Justice will exercise his power. This is how the rules will be made and this is who will know of the rules and who will find out about them. Let's put that in place. So I think a lot of these things, unlike, say, the legislature, which directly feeds into where, to an extent, your MPs and MLAs are in some way responsible to constituents, are in touch with their constituents, judges are kind of cut off in that way. They are not always necessarily, and they tend to react more than proactively think of such certain situations. So I guess what could happen here, and the best case would be people recognize this is a failing. We will rectify this failing now.
Okay. So I want to follow up on that on two counts. One is sort of focus on this appointments issue. And there's been some attempts at changes on that. And the second is to go back to see who can drive changes internally, right? So even if, say, nothing happens over the next few months, but Justice Gogoi becomes the CJI next, what can he do in his position? So first on judicial appointments. So there was the NJAC bill that came about a while ago. But can you both enlighten me a little bit on how this collegium got formed in the first place and, what the NJAC tried to do?
We could spend the rest of the day here, but I will be as quick as possible. See, India, we have had 3 appointment mechanisms so far. And it's all been by convention. The first one was between 50 to 71, when whatever the Chief Justice of India said, the government would appoint.
Okay.
As far as Supreme Court is concerned. 71 to the to 93 was where the executive said we want an equal say. So yes, of course we will listen to the Chief Justice, but hey, see Chief Justice, maybe these guys also somebody you would want to consider. So there's an equal interplay. At some point the executive would have more power over the Chief Justice, the Chief Justice would have more power over the executive. But it became intolerable when appointments were being held up because the executive wanted a greater play in it, a greater role in it. So the collegium system was a reaction to this. The collegium system was the judiciary saying, okay, I think we made a mistake by treating the executive as equal. The executive does not see us as equals and wants to constantly, like that proverbial camel and the sheikh, and constantly trying to push us out. So the collegium system was a reaction to it. They said, okay, you know what? We feel that it just can't be the Chief Justice alone because there'll be more pressure on the Chief Justice. We feel that what was an informal convention of the Chief Justice speaking to senior judges has now to be put in hard and fast rules. So we'll say it'll be the 2 senior judges. It took 5-6 years before the collegium system became crystallized into what it is now. And there was a lot of back and forth. It was never an easy process. Lots of judges disagreed with the system, operated it, and then they saw the merit in it, and then they said, okay, fine, let's continue with it. So there's a period of, I wouldn't say tussle, but disagreement and adjustment. So from 99 onwards, we have the collegium system as it stands now. But to come to the present system, it's not workable. You are talking about a body of 5 gentlemen, mostly, and very rarely women, who have the task of appointing and keeping track of 1,000-odd High Court judges, apart from their own Supreme Court judges. Right? We are talking about them figuring out how to appoint for efficient. So I did the numbers on this, and there is no way the collegium system, even at its most efficient, is ever going to leave us with less than 30% vacancies in the high courts. The capacity is just not there.
Or just the ability to hire.
Just the ability to find. Because it's a complex process. You're not talking about, I'll see your CV, you're fine enough, good enough, I'll appoint. You're talking about multiple stakeholders being involved. You're talking about the High Court in question being involved, the government being involved, different parts of the government being involved. There are lots of moving parts. Keep in mind, the collegium is only the 3rd priority for the top 5 judges. They have their judicial work to finish. They have their administrative work to finish. Then they have to do the collegium work. Where are they going to find the time? Right? So, whole debate about judiciary versus executive, I think, is entirely orthogonal to the problems of the appointment system. It is a system that is essentially broken down. It doesn't matter how many posts you create in the high courts. The collegium, in my view, is never going to be able to to ensure that there are more than 750 judges in the high courts at any given point of time. They just don't have the capacity. Supreme Court, that they're going to be able to handle because it's the smallest institution. You only need to appoint 2, 3, 4 judges a year. You'll be fine. But for high courts, it's a couple of orders of magnitude more of a problem to appoint enough judges. So it's not going to be something that is going to be resolved quickly. The other problem with the collegium system has been the lack of transparency. We don't know why X became a judge and not Y. Now it is being addressed to some extent. They are putting up collegium resolutions on the website. Some people have problems with it, but I think we're not going to go back to nobody knows anything about these things. They may find a way to improve privacy and so on, but only now do we know that, okay, so this guy got rejected because doesn't seem to have had enough of a practice. or this person has objections have been raised against this person's character by somebody in the know.
The other thing that you asked is, who's going to drive this change? Unfortunately, again, the way we have painted ourselves into a corner, the judiciary has painted itself into a corner, change has to come from within the judiciary. And who is going to bring this change? I don't know, right? At any given point of time, I think less than 10% of the judges, I'm talking about High Court and Supreme Court, are really interested in looking at some of these institutional issues. Otherwise, they're busy. They may be interested, but they're busy with day-to-day transactions, meaning they're busy with day-to-day cases, day-to-day issues that they have to deal with. And nobody is thinking about the institutions, right? And to give you an example, in a couple of courts that we were looking at, high courts, one senior judge was the chairperson of about 6 or 7 committees. So the High Court, the Chief Justice delegates his powers to different judges, and there are different committees like Arrears Committee, right, Buildings Committee, Appointments Committee, now Computer Committee, whatever. And the same judge, the same senior judge, was chairperson of about 6 or 7 committees. Each committee met only once in 13 months. Right? And everything is decided by them, because the administration in the high courts is nothing to speak about. Most of the registrars, almost all the registrars are basically district judges who have been seconded. They don't speak up. They don't voice, independent opinions on how administration is done. So I'm hoping that at least this event of going public with administrative problems will lead to some sort of initiative to reform the administration, judicial administration. And look at how guarded I am and how, what shall I say, how cynical I am of my own hope. Okay, if that can ever happen, I'm hoping that this will lead to it, but I'm very, very, very conscious that it's a long road, right?
Okay.
So what can the executive or the legislature do? And I actually think the legislature should take some action to bring about administrative reforms in the judiciary without affecting judicial independence. They can provide that, the administration will report to the Chief Justice. Okay, there's no problem. I don't think we should violate that. But the judiciary is incapable of thinking of administrative reforms, and they need help. The point is, some of them are willing to accept help, but the executive also needs to take initiative. Hopefully, something will happen.
Where can change come from? I think the bar is an equal stakeholder. I think a lot of our problems with the judiciary can be traced to the fact that our bar has steadily weakened over 3 or 4 decades of complete neglect in legal education. Slowly, we are trying to fix it with more investment in legal education, but we are seeing the effect of about, say, 3 decades of almost zero investment in legal education. Apart from NLS, and it took about 10 years after the first National Law School was set up in Bangalore for Nalsar, NUJS and others to be set up, and now everybody wants to invest in legal education. 30 years before that, you had almost nothing. So in that way, we are now seeing the effects of that. It's going to take a long time to fix. But at the end of the day, if I have to pin any hope on, I will pin my hope on the bar acting in its self-interest. The reason why I say this is because over the last 4 or 5 years, the number of civil cases are actually falling in this country, which is completely against international experience, which is completely against any other expectation of what happens in an economically growing and population growing country. We're supposed to see more cases, but we're not. We are seeing the number of civil cases falling. If you eliminate tribunals, even if you eliminate other quasi-judicial bodies, it still does not explain why they are falling. They may have slowed down the growth, but nobody can explain adequately why they're falling.
Right.
And they're falling simply because, guys, the thing that you took so much for granted, public confidence in the judiciary, is eroding. Like, even as you see it, it's eroding. At some point, it's going to hit the bar home that this is our basic sustenance and it is falling away right under our feet.
I have a very different note of optimism in that a decade ago, I don't think either Daksh or Vidhi existed. Right. So the idea that along with the bar doing other things, people with a legal background coming out into the think tank space, into other spaces, is a positive sign in the long run. Because one of the things I see as a non-lawyer is a lot of the times when lawyers are speaking, I'm not able to understand what's happening. And I think that has significantly changed in the last few years, where suddenly I think the crosstalk is happening a lot more. So again, very gentle points of optimism over here. I think I did detect a large note of conservatism in the optimism.
Yeah, conservatism of hope. Right?
Conservatism of hope.
Because I'll tell you, there was a report on the Indian judiciary in the early part of the 20th century, and you could reproduce it almost word for word, just changing the dates, and it still hold true. The problem of arrears, the problem of capacity, the problem of qualifications, the problem of delays, pendency. We've been dealing with this for 100 years now. But again, I suppose some things will never go away fully. And it's not going to be easy to reform it either. So it's just sort of why, when you say, okay, let's chip away a little bit, let's chip away a little bit, let's chip away a little bit. That's the only best we can.
Thanks so much for coming in, Harish. Thanks, Alok.
Yeah, it was a pleasure, Pavan.
Pleasure.
Thank you, Pavan.
Thanks for tuning in to the Pragati podcast and staying with us till the end. If you want more views on what's happening, read my colleague Madhav Chandavarkar's piece on thinkpragati.com titled The Runaway Judiciary. Send us your questions, comments, and brickbats by writing to podcast@thinkpragati.com. You can find the Pragati podcast on your favorite podcast app. We're there everywhere.
There she stands, a podcast addict. Outside the bank, having travelled several miles to get in with other poor souls like her. The journey, though daunting for this youngling, will have some comfort because she has downloaded her favourite podcast. You can see more of her species on ivmpodcasts.com, your one-stop destination where you can check out the coolest Indian podcasts. Happy listening.